Welcome to Penn State Dickinson Law's Profiles in Leadership series. My name is Daryl Lim, and I serve as the H. Lenny Montague Jr. Chair in Law and Associate Dean for Research and Strategic Partnerships here at the Law School. This series offers an opportunity to learn from top leaders in their respective fields, people whose work, vision, and character continue to shape their professions and communities. In each episode, our guests reflect on their journeys and share their values, experiences, and the qualities that define their leadership. Today, I'm honored to welcome Lord Justice Richard Arnold, a distinguished member of the Court of Appeal of England and Wales. Lord Justice Arnold was born in Chelmsford and raised in North London. After studying chemistry, he trained as a barrister specializing in intellectual property, media, and technology law. He was appointed to the High Court's Chancery Division and later served as judge in charge of the Patents Court, before becoming an external member of the enlarged Board of Appeal of the European Patent Office. He is the author of several leading works in IP law, including Performance Rights and Halsbury's Laws of England on Trademarks and Trade Names. In recognition of his contributions, he was awarded an Honorary Doctor of Laws by the University of Westminster. Outside of the courtroom, he enjoys cooking, walking in Suffolk, and watching cricket. Welcome to Profiles in Leadership.
Thank you. It's good to be with you.
So let's talk about your early influences. What do you remember from your time in Chelmsford and North London?
Well, if you'll forgive me, it's pronounced Chelmsford, which is a town in Essex to the northeast of London. And that was where I was born. But my parents didn't stay in Chelmsford for very long, or indeed in Essex for very long. They subsequently moved to Basildon, which is also in Essex, and they moved to North London when I was 2. So my memories of Essex are nil. I grew up in North London, and in particular an area in North London called Hampstead Garden suburb, which is, as the name implies, quite a green area. So it was a very good place to grow up, and I was fortunate enough to receive a good education from a school in North London called Highgate School.
Thanks. How did your scientific background influence your approach to legal reasoning and problem solving?
Well, there's two aspects to that question. Part of the reason why I'm where I am is that having studied chemistry, as you mentioned, but then having decided not to pursue a career in chemistry, when I changed direction to the law, I didn't want to waste the time that I'd spent studying chemistry. And so patent law was a natural fit for that, although, as you mentioned, I didn't just practice in patent law, I did intellectual property law more generally and allied fields. But if one is dealing with patents, it is inevitable that a scientific education is useful, if not essential. But more generally, what I would say is that I think a scientific education is of value to any lawyer because it teaches logical reasoning, and logical reasoning is, of course, highly applicable in the law.
So do you remember any uh, episodes in law school that you think might have been formative, or we call them law school here, I think in the UK, really at the Faculty of Laws, uh, that you think helped shape the way that you looked at the law, the way that you looked at being a judge?
Not really, but to explain my answer, I need to explain something about the system of legal education in this country. So there are basically two routes in. The first route is that one takes a law degree at a university. And in this country, by contrast with the US, that will be an undergraduate degree. But the alternative approach, which is more similar to the US but nevertheless different, is that having taken a degree as an undergraduate in a different subject, like myself, I study chemistry, but it could be history, it could be languages, it could be all kinds of things. You then do what's called the graduate diploma in law, and what that means, in essence, is a 1 year crash course in law in which you study the basics of a law degree, but stripped of anything that is not completely essential. So that's what I did. And it leads to this consequence that I am a judge in my country, but I have no law degree. And that's not uncommon under our systems, whereas there are plenty of systems of law where that would be quite inconceivable. But the result of that is that not having had a thoroughgoing legal education in the sense of having been to university for a 3 year course and only having studied it for 1 year, my legal education was not complete at that point, and I was obviously continuing to learn a great deal in subsequent stages. First of all, reading for the bar. Secondly, becoming what we call a pupil barrister. And indeed, even in my early years of practice. So it was very much an ongoing process.
Just anecdotally, over the years, observing folks that have gone through the, I suppose, more formal route of legal education with that undergraduate degree that you described versus one where you come in with a scientific background or a prior degree and then you do that crash course. Uh, have has one group shown different characteristics, different strengths, weaknesses compared to those in the other group?
Well, when you're dealing with patents, I think it's fair to say those who don't have a scientific education can sometimes struggle. And it's not because of the law, it's because of understanding the technology and therefore applying the law to the facts. More generally, I'm not sure it does make a big difference. I mean, in our history in this country, we've had eminent judges with what we would now call STEM backgrounds, so science, technology, engineering, mathematics. And I'm not sure that unless you knew them, you would be able to tell that. So let me take a famous example from the middle of the 20th century. We had a judge called Lord Denning. He was, in fact, when you look back at his personal history, he was a mathematician when he was at university. But I'm not sure you would know that if you just read his judgments. You would certainly see that he had quite an individual style of writing them, and he was a renowned exponent of jurisprudence in his day. But I'm not sure that it's obvious that he had a mathematical training. By contrast, you can look at some eminent judges in our history who've had degrees in humanities subjects who reason in a very logical way. And again, it's not obvious that they don't have a STEM degree.
You mentioned Lord Denning, and one of the things, of course, he's known for is really being very active in developing the law, sometimes extra textually when it comes to statutory interpretation. Uh, what is your take on this tension between being faithful to the text of the statute versus being responsive to the needs of the case before the judge?
Well, that's something that is inevitably context specific. It very much depends on the particular point that's at issue and the broader context that the point fits into. But as a matter of generality, what I would say is that even if you are dealing with a question of legislative interpretation, there are very few cases which come before a court in which the legislation will speak entirely for itself in such a way as to admit of no argument as to what the correct answer is. Of course, that's not to say that there are not situations in which the legislation is perfectly clear, but such cases don't come before the courts, and certainly not before courts of appeal. So you're usually concerned in litigation with legislation which is not so crystal clear as to admit of only one answer. indeed more generally, it's quite difficult, I think, for legislators to draft legislation in such a way that it does admit of only one answer. And even if where that is possible, it may be undesirable, as the familiar debate about rules versus standards tells us. Therefore, you are almost always concerned with situations in which there is some role for interpretation and application for the law. And that is the judge's responsibility. And how that plays out in any particular case depends, as I said earlier, on the particular context. Uh, in this jurisdiction, we are not slaves to literal interpretation and have not been for a long time. The fundamental goal of legislative interpretation, according to our jurisprudence, is to adopt a purposive interpretation, which pays due regard to the text, but also tries faithfully to implement its purpose.
Thanks. So let's take a step back. You graduate, you go into practice, you're a barrister. Uh, it's a bifurcated system in the UK. In the US, it's a fuse system. Talk a little bit about the differences between practice in the UK and what you observe here in the US, and what was the experience like for you as a barrister?
Okay, so as you say, there is a formal difference in that we formally have a split profession between barristers and solicitors who have somewhat different but nevertheless overlapping roles, and the US, where there is not that formal split. But I would suggest that, based on my limited experience of what happens in US law firms, that actually you find a very similar split in US firms as a matter of reality. You have people who practice as trial lawyers, and people whose practice is in non-contentious areas. And that's very similar to the split between the bar and the solicitor's profession in this country. So there isn't the formal distinction, but that in reality, there are different roles in the law, no matter what labels you happen to apply to them.
Was it a fun time for you as a barrister? Looking back, uh, what were some of the highlights of your time as a barrister?
Well, yes, it was fun. It was hard work, but I enjoyed my time at the bar, both when I was what we call a junior barrister and then when I became a QC. And uh, it was hard work, but it was very enjoyable work. I was very fortunate, as it turned out, because when I changed course from chemistry to law, I had no idea whether I was going to be good at it. I had no idea whether I was going to enjoy it. Um, Still less did I have any idea as to whether I was going to be able to make a living at it. But it turned out, to my great benefit, that I seemed to be really reasonably good at it. I was able to make a good living, and I thoroughly enjoyed it. And there were all kinds of highlights in that time, but I will mention just one, which is somewhat in my mind at the moment. Towards the end of my time at the bar, I had the privilege of representing a man called Dr. Lionel Sawkins, and he's in my mind at the moment because he passed away not long ago, at the age, I think I'm right in saying, of 96. Now, Dr. Sawkins was an eminent musicologist and musician, specializing in the music of the French Baroque composer Michel Roland de Lalande. And he got into a copyright dispute with a record company called Hyperion Records. And the issue in the case was whether performing editions, which Dr. Sawkins had created, of works by Lalande were themselves the subject to a separate copyright. of course, Lalonde's compositions, having been created in the 17th century, were way out of any copyright, even if there had been copyright at the time. Um, but the question was whether, in creating his performing editions, Dr. Sawkins had created something which attracted copyright protection. And the essential question was, were they original by reference to the compositions that they were editions of? And it, in fact, involved a lot of skill and work on Dr. Sawkins's part because he had to track down sources in manuscript and printed sources. He had to decide which was the best. He had to correct the errors. He had to supply missing parts, and so on and so forth. Anyway, the trial judge had decided in favour of Dr. Sawkins, and I wasn't involved in that stage, but Hyperion, undaunted, decided to appeal to the Court of Appeal, and I was instructed on behalf of Dr. Sawkins on the appeal. And I had the rather unique pleasure of being able to open my address to the Court of Appeal in response to the appeal by saying that not only was the trial judge's decision predictable, but I had in fact predicted it in my book, published not only before the trial judge's decision, but before the events in question had actually taken place, because I had posited a hypothetical example in my book. This is my book on performers' rights. And the facts of the hypothetical example precisely matched what actually happened in the Sawkins and Hyperion case. And the answer I'd given in the book was that copyright would subsist. So that was a rather remarkable pleasure to be able to do that. And the upshot, I'm pleased to say, was that the Court of Appeal dismissed the appeal, so Dr. Sawkins was successful in his claim.
Well, congratulations. Before we go on the conversation about your journey to becoming a judge, let's talk about being a King's Counsel. What is the process of one becoming a King's Counsel? Is it more of an art or more of a science?
Well, these days it's more of a science. The process has changed since my time, and nowadays there is an independent body whose job it is to assess applications to become what is now, as you say, King's Counsel. And it's a body with both judges, lawyers, lay people represented on it. And it's quite an elaborate process. Applicants have to fill in quite a long form. And then there's a detailed process of obtaining assessments from those who are acquainted with the applicant's work. So those will be other lawyers, barristers and solicitors, and also judges before whom they've appeared. And then the assessment body takes all that information into account and decides who meets the requisite standard and who does not.
And how easy or hard, just in terms of a rough percentage, is it to become a King's Counsel?
I couldn't give you accurate and up-to-date statistics as to the success rate, but it's not easy. The last statistics I remember seeing, I think there was something like a 20 to 30% success rate, but it could be higher than that. I'm struggling to remember.
Yeah, of course, before that, people may themselves decide not to apply because there's a self-selection process.
Well, certainly. There's a self-selection process, both in terms of do people think that they're of a high enough standard, and do they want to put in the necessary work and pay the fee, because you have to pay a fee to the assessment body, because obviously it's quite an expensive process to administer for the reasons that I've explained. So the only people who tend to apply are people who are sufficiently self-confident to think that they do meet the requisite standard and are prepared to put in the necessary work and pay the fee.
And do you get the feedback if you're successful?
Well, if people who are successful will be appointed as King's Counsel, those who are unsuccessful can ask for feedback as to why they've not been successful, and they are given it.
Oh, okay. So during your time, it was Queen Elizabeth who was the reigning monarch. Did you get to meet her?
I did indeed. Not when I became a QC. Those days were long gone. But when I became a High Court judge, I did have that privilege because under our system, if you become a High Court judge, you automatically have a knighthood bestowed on you if you are male, or you become a dame if you are female. And in my time, those who had that honour had the privilege of a personal meeting with the Queen on the occasion of being knighted. So I had a one-to-one audience with Her Majesty when she knighted me. Not for very long, 20 minutes or so, but obviously that was a great privilege.
Do you remember the conversation?
I do, but I'm not at liberty to disclose any of it.
Okay. Well, so you become a QC and you continue practicing. At some point, you decide that you want to become a judge. How did that process come about?
Um, It was a gradual realization. I mean, when I went into practicing as a barrister, I had no such conception. But as time wore on, I grew more and more interested in that possibility. And part of the reason for that was that, of course, intellectual property law, particularly in those days, was quite a niche speciality. There were a limited number of people practicing in the field. And so one was aware of people who either shortly before my time or during the time that I was a barrister had made that transition from bar to bench. And so one could see that happening in front of one's eyes, as it were. It not only provided an example, it provided an inspiration, and it obviously led to one thinking, well, is that a route I want to follow? And as time wore on, I got more interested in doing that. And what that then led to was that under our system, it is at least common and indeed almost de rigueur, if you wish to become a full-time judge, to first of all undertake a part-time position. There are a number of part-time positions available in our system, and indeed the system really depends upon the contribution that part-time judges make. So my first step on the ladder was to apply for and obtain a position as a part-time judge. And in my case, being an intellectual property specialist, what that involved was a position hearing appeals in trademark cases from the trademark registry. And then that led on to another part-time role as a deputy High Court judge. And after I'd been a part-time judge for 5 years, it seemed to me that I was enjoying being a judge more than I was being a barrister. And so I decided to make the plunge and apply to become a judge full-time, even though it would involve a fairly substantial cut in my income.
So a few questions there. We'll start with the last one, talking about income. I think for many people here in the United States as well, the move to public service is always a daunting one because you are usually at the stage of your life where you've got to think about family obligations, retirement, and all these other things, quite apart from the standard of living that you become accustomed to having achieved a level of success in professional life. What was the internal reasoning process that you led you to that? And more broadly, when you talk about barristers thinking of going into the judiciary these days, what advice do you have for them?
Well, the calculation is always an intensely personal one. It always depends upon one's personal circumstances, and they, of course, vary hugely. At the stage when I made the transition from being part-time barrister, part-time judge to full-time judge, I still had two children in school. My youngest daughter at that point in time was just about to be 8. She was 8 soon after I was appointed. And we also had an elder daughter who was just about to be 12. So in that sense, one might say, well, it wasn't a very good time to make that move, given the family responsibilities that I still had. But on the other hand, I had two advantages looking at it purely from a financial perspective. First of all, I'd been doing well at the bar, so I you know, I had a nice house, and so I didn't need to worry about that kind of thing. In other words, I had a cushion, if you will, as a result of the success that I'd had in private practice. Moreover, the advantage of moving to the High Court bench as opposed to some other judicial positions in this country is that by comparison with other positions, it's well paid. I mean, as an entry level full-time position, it's the best paid. There are other positions lower in the hierarchy which are less well paid. And obviously that is clearly going to be a factor in the equation.
Do you think there's, oh, no, please go ahead, because there was a second part to my question
Well,
about
well,
advice.
because these questions are never just financial,
Mm.
because you also have to think about your enjoyment of the job, and I've already touched on that aspect. But also, then there's the question of how such a move affects your work-life balance and how it impacts on your family. And the view that I took at that time was that I was hopeful that it would improve my work-life balance and improve family life, because historically it was certainly said quite commonly prior to that point in time that a good reason to move from the bar to the bench was that there would be less pressure and you would have to work less hard. Now, I'm not sure about the working less hard as it turned out. I'm not sure that I ended up working less hard when I was in the High Court than I had done when I was at the bar. But on the other hand, I think it was less stressful. There was pressure, but it was a different sort of pressure. And so, on the whole, I did find it less stressful. And that was certainly beneficial for family life.
Great. Let me ask you about attracting the best and brightest into the government or the judiciary. People who feel, quite apart from the better work-life balance that you might get, that they're not quite prepared to step forward. Public scrutiny, of course, the cut in salary. Public scrutiny you can't do a whole lot about, but some jurisdictions, for example, in Singapore, have looked at pegging the salaries of civil servants and judges to the private sector with appreciable discount, but nonetheless with some benchmark that allows remuneration to keep pace with the earnings that are foregone. Do you think there's merit in looking at that in the UK?
Well, that's a sensitive subject, so I need to be careful what I say. But certainly there is data to suggest that judicial earnings in England and Wales have not kept pace with earnings in the private sector over the period that I have been a judge. So that's since 2008. And of course, we have had pay increases in that time. And I don't know off the top of my head what the data would show in terms of the extent to which the pay increases have kept pace with inflation. But in private practice in the law, particularly in London and particularly in specialist areas, I think the data shows that salaries have increased more than inflation has generally in the economy. And so the net result, as I say, is that judicial salaries have not kept pace with earnings in private practice, particularly, as I say, in those more specialist areas. Other areas, that's less true. Now, what one does about that is obviously open to debate. So you could try and do something the kind that you're doing. I mean, what's going on in this jurisdiction at the moment is that there is a body called the Senior Salaries Review Board, whose job it is independently to assess remuneration for not just judges, but other public servants in all kinds of sectors. And they undertake annual reviews, which result in recommendations being made to the government as to how remuneration should be increased. But what they also undertake is periodic major reviews where they look more widely and look at things like differentials and how public sector remuneration compares with private sector remuneration. So that process has just been started and we'll wait to see the outcome. The final observation I would make on this topic is that of course, an important factor in the equation, as always, is pension provision. And one of the attractions of becoming a judge in this country is that the pension provision is quite generous. Whether it's as generous as in the US system, I'm not quite sure. But it's fairly generous, and that is certainly an incentive to join the judiciary because that it goes a considerable way to offsetting the reduction in salary.
So one of the things which is a feature of the US judiciary system is you're appointed for life. Is that also the case in the UK?
No, it's not. So at the time that I was appointed, we were subject to mandatory retirement at the age of 70. Just over 3 years ago, that was increased by the last administration, and it is now mandatory retirement at the age of 75. On the other hand, it's perhaps worth adding that the difference is slightly less than it might appear because although there was mandatory retirement at 70 previously, if you were sufficiently senior, you could carry on sitting as a judge after retirement on a part-time basis until you hit 75. So in some ways, you could say that the difference under the new system is that you can carry on full time rather than only part time, although there's a little bit more to it than that. But yes, so currently the rule is 75.
The justification here for lifetime appointments is independence of the judiciary. Do you think that's overstated?
Yes. I cannot begin to see how mandatory retirement at 75 or even at 70 is any threat to the independence of the judiciary whatsoever.
All right, thanks. So going back now to your first day as a full-time judge, do you remember that day?
Well, of course, the first day as a full-time judge for me involved no judging at all. Uh, it is quite common in this jurisdiction. No, it doesn't always happen by any means, but it is quite common for people to be appointed at the beginning of the legal year. So we have legal terms just like schools and universities, and we have a legal year just as there's an academic year. And like the academic year starting typically in September, our legal year starts on the 1st of October. And it is a long-standing tradition for the legal year to commence with a service in Westminster Abbey, followed by a reception at lunchtime in Westminster Hall. And if you are a sufficiently senior judge, you will automatically be invited. More junior judges are invited in turn, as are senior members of the bar and the solicitor's profession. And we also have a few other guests, such as judges from some other jurisdictions. And it's a grand occasion, and we all dress in ceremonial dress. So when you see photographs of English and Welsh judges in the media, frequently the photographs that are used are photographs of us in our ceremonial dress, which many of us will only wear once a year. And so there I was, dressed up like Father Christmas, in a High Court judge's ceremonial outfit. And I went to the service in Westminster Abbey, and I went to the reception afterwards. And that was the main thing that happened on my very first day as a judge, because the 1st of October 2008 was my first day as a judge.
Thanks. You mentioned a service in Westminster Abbey. How much is religion or Christian thought, you think, part of the legal fabric of modern UK jurisprudence?
Well, it's undoubtedly the case that historically Judeo-Christian ethics have formed quite an important part of the law in this country. And that's true in all kinds of reasons, which would take quite a long time to discuss. But let me give you a simple example. As many people will know, we have common law on the one hand and equity on the other hand. And the equitable jurisprudence was created by the Court of Chancery. And the Court of Chancery was, in some ways, the successor to the ecclesiastical courts. That's not an exact mapping, but in some ways that's true. And certainly the judges in the Court of Chancery avowedly acted upon conscience. They were, of course, judges applying law, but in formulating the legal doctrines and principles that they applied, they looked to conscience to guide them. And in looking to conscience, what they meant by that was Judeo-Christian ethics.
And today, is there an expectation that a judge taps into that same stream of jurisprudence, or is it more of a, if you like, a modernist, atheistic, or agnostic, secular view of the law, where a judge is really a neutral arbiter to the extent that could be possible, and you're just applying the black letter law to the facts, apart from the judge's personal convictions or value system?
Well, there's a number of different factors wrapped up in that question. First of all, yes, undoubtedly the law is secular, and it is inherent in modern jurisprudence that it is to be applied impartially. And we would certainly take the view that impartial application of the law involves application of it without regard to religious or ethical systems of those involved, except, of course, in circumstances where that is part of the issue before the court, because of course sometimes you have litigation involving questions of freedom of religious expression. And so in such cases, you may have to get involved in that sort of inquiry. But the general proposition is that the law is to be implied impartially, without regard to the religious or ethical convictions either of the judges involved or the litigants. It's entirely neutral. The extent to which the law is still informed by value systems that have foundations in Judeo-Christian ethics is perhaps debatable. Given the long tradition we've had in this country, I doubt that one could be confident that that's been eradicated. But on the other hand, certainly over recent decades, we've had the benefit of judges who are of different faiths. That's nothing new, but it's increasingly been the case that we've had judges who are not merely Christian by faith, but Jewish, Muslim, and so on. And furthermore, there are plenty of judges like myself who are atheists. And so we certainly have a much more pluralistic judiciary and a much more pluralistic view on legal thought than in the past.
And for judges, even in more technical areas like patent law, for example, who have to decide whether or not a genetically engineered mouse is patentable or whether it's contrary to public order and morality, or in trademark law, we've got marks that may not be registered because, to use the physiology here in the United States, they're scandalous, immoral, or disparaging in some way. How would a judge in the UK approach these types of issues?
Yes, well, of course, I'm aware that the US Supreme Court has held that that test is unconstitutional because it's viewpoint discrimination. But that's by the by. But the answer to those kind of issues is you can't possibly decide issues like that based on your own personal values. That would be antithetical to the rule of law. So questions like that have to be addressed objectively, applying objective legal principles, not applying the personal beliefs of the judge who's involved in deciding the case.
So you appointed about 6 years now on the Court of Appeal. You mentioned legal year starts in October, so about 6 years to the date. Looking back at
Yes, it's a whole limitation period ago. It's quite striking.
looking back at your time on the Court of Appeal, uh, really from the perspective both of where you are now, but also when you were looking ahead at the judicial career and that transition, what do you think you learned from your time as a judge that you might not have realized as a barrister? About leadership, about judging, about the law, about the system. Take it however you like.
Well, a great deal. When I became a full-time judge, as I've explained, I'd spent 5 years as part-time judge, so I inevitably had some idea of what I was embarking upon. But like any job, you never know the full reality until you start doing it. And certainly there are dimensions to the job which I either didn't anticipate or were not fully aware of, or certainly my thinking has evolved over time, inevitably. But yeah, it's quite hard to discuss that in general terms, um, because a lot of it is quite inseparable, certainly looking at it from my perspective, of simply becoming more mature and more experienced anyway. I mean, by our standards, and this is emphasize by our standards, I was appointed to the High Court bench at a relatively young age. So I was just 47. In fact, when my appointment when I received the news that I was going to be appointed, I was still 46. By the time it actually took effect, I was 47. That was relatively young by our standards. I'm now 64, and inevitably being that much older, I have more experience of the law and more experience of the judicial system. And simply having that much more experience inevitably changes your perspective. But I think that would have been true to some extent, even if I'd stayed at the bar.
So is being a judge a lonely existence because there's this need to appear impartial and you can't really interact with members of the profession the way that a solicitor or barrister might. How is it like being a judge?
So,
Social.
so I would give a very firm no to that answer, that question. Historically, it was perceived as a lonely profession in this country. And the reason for that was that it used to be the case that the thinking was that in order to be independent and impartial, judges had to be isolated. And of course, if you are isolated as a judge, that inevitably carries with it the very real risk of loneliness. But I'm happy to say that ever since I've been a judge, a more enlightened view has been adopted, and it's certainly true now, which is to say that we now think that judges can be independent and impartial without being isolated. Indeed, I think we now appreciate that being isolated is not only bad for the individual in terms of the individual's mental health, but also it's bad for their professional skills as well. So the modern philosophy in this country, as far as judges are concerned, is that yes, we should be independent and impartial, but we should not be isolated. On the contrary, we should be engaged. And so that means, first of all, that one has the traditional benefits of a judge of collegiality amongst judges. That's always been true. But I think there's even more emphasis on that aspect of the job than there used to be in the past. But over and on top of that, it's recognized that it is valuable for judges to be engaged with the professions and also, I would like to emphasize academia and indeed the public more widely, both because it's good for judges on a personal level, but also much more fundamentally, it's good for our professional skills, and it has other benefits too.
So a couple of interesting nuggets there I want to dwell on a little bit more. First, the academia bit. And you have been involved actively in not just the business of judging, but also in the business of developing our understanding of the law in academia, whether it's through lectures or whether it's through, I'm not sure if you teach, but you certainly have that, the treatise, the books that you write. Um, how
I
first,
don't teach, but I do give a lot of lectures, and I would distinguish between those two activities.
yeah. How do you keep a balance with all the things that you need to do, first of all, in terms of time management, but also how do you avoid a perception that somebody who picks up one of your writings might use that to extrapolate how you might decide or interpret a particular issue in a case?
Well, the time management question is a good one, to which the only answer I can give you is I try and be efficient. And I try and use my time well, and therefore to have time available for academic activities as well as for the day job. And I've been reasonably successful in that to date. How long that can be maintained, I don't know. But I think it's helpful that in my experience, the academic activity is to some extent reinforcing of the professional activity because what I learn through academic engagement is beneficial to me as a judge. So it's not as if it detracts from the day job, provided that I manage to have time available to do both. In terms of the other aspect of your question, which is prejudging, well, that's inevitably a case by case issue. I mean, I'm fortunate in that respect, in the sense that my book on performers' rights is on a relatively niche subject. It does deal a bit with copyright more generally, but it is mainly about performers' rights, and they quite rarely get litigated. So in my time in the Court of Appeal, we've had precisely one case on performers' rights so far. And it was on an issue that wasn't, I mean, it was touched on in the book, but it was quite a niche issue. So I don't think anybody was concerned about it having been prejudged by what I'd written in the book. But in principle, you can imagine objection on that score, and obviously one would have to consider the merits of that as and when it was raised. I mean, if necessary, one would recuse oneself, but so far that question has never arisen.
What is the judiciary's view on foreign legal judgments on topics that touch on the same issue?
Well, again, that's something that has changed over the course of my professional lifetime. When I came to the bar, I think there was still a vestige, and perhaps even more of a vestige, more than a vestige, of the attitude, subconsciously, if not consciously, that English law was best and we had nothing to learn from anybody else. That attitude was never entirely true, actually, historically, because when you look at the development of the common law, particularly over the course of the 20th century, what you can see is that actually English law took inspiration from fellow common law jurisdictions, not so much the US, but particularly Australia, Canada, and New Zealand, and to some extent Hong Kong, South Africa, Israel, and latterly, of course, Singapore. So it was never true to say that English law was entirely isolated. There was always a degree of cross-fertilization with other common law jurisdictions, and to the benefit of all. But certainly in my professional lifetime, it's been entirely accepted that no legal system has a monopoly of wisdom. We can all learn from each other in trying to find common problems to common solutions. And in particular, we've gone back to an attitude which actually is not new in our history. If you go back to the time of Lord Mansfield, he was heavily inspired by doctrines and principles that he absorbed from civil law systems. And that we somehow got out of the habit of that. But I think partly as a result of joining the European Union as it became, we have become reacquainted with that part of our law, and we have relearnt the lesson that common law is not in somehow entirely divorced from civil law systems. On the contrary, they are more similar than they are often portrayed as being, and we can learn from our civil law colleagues just as we can from our common law colleagues.
So you mentioned the US as an outlier in terms of how the UK views relevant or maybe applicable streams of jurisprudence. Why do you think that is?
It's quite hard to say. I mean, it's partly because of the division between federal law and state law in the US, which has no counterpart for us, at least prior to devolution. I mean, devolution's altered that a little bit, but not much. Partly because of the different statutory context, and partly because somehow the stream of the common law seems to have flowed in slightly different channels in the US as compared to the other common law jurisdictions. I mean, let me take a simple example: contract law. And this is I think quite a good illustration of what I'm trying to say. So my understanding, and you will correct me if I'm wrong about this, but my understanding is that contract law in the US is a matter of state law. It's not federal law. And so if we're looking for inspiration, we can't look to one source, a federal source. You would have to look at all the state sources. And that's a disincentive straight away. Moreover, at least some of the state laws, for example, on questions of contractual interpretation, have gone in a bit of a different direction to the approach that is taken in the other common law jurisdictions. Now, what the reasons for that are, I'm probably not qualified to comment on, and are probably debatable in any event. But the net result is that English courts looking for inspiration on contract issues have tended to find it easier and more helpful to look at other jurisdictions like Australia, where, first of all, you've got a single source of relevant jurisprudence, and secondly, the jurisprudence has stayed closer to our own.
Thanks. You see, they were almost at time, and I want to be respectful of that, but I do have a few more questions. Is it all right if we run over about 5 minutes?
Sure.
Thank you. Let's talk about mentors. How important has mentorship been in your life, either as somebody that's received mentorship, and if so, who that mentor figure or figures might be? Are you involved in mentoring others at this point?
Let me answer the first part of the question first. So, mentoring is something that we place a great deal more emphasis on in this jurisdiction than we did in the past. I mean, it's something that always happened informally in the past, of course, whether you realized it or not. I mean, when I was a barrister, certainly had a mentor who was very influential in my becoming a judge, but I don't think I knew that was what was happening at the time. And I'm not even sure that he regarded himself as my mentor. It's just that that was, in fact, looking back with the benefit of hindsight, that was the dynamic, even if neither of us would have articulated it in those terms at the time. But nowadays, we're much more conscious of the value of mentoring, and we actually have formal processes for doing that. And this is something that is not just true of the judiciary in England and Wales. This is something that is true outside the judiciary as well. So, I mean, my wife works in the National Health Service, where mentoring and through formal processes is regarded as very important and helpful. So this is not just the judiciary. I have to own up to the fact that personally, perhaps because of my specialization, I'm not much engaged in formal mentoring. I mean, I do a certain amount of informal mentoring in various ways, and I'm probably should do more.
Thanks. So let's talk about the Fordham Conference, which is where you and I met many years ago, and you take the trouble to come across the pond, as we put it, to be part of that conversation. What is it that draws you to international fora like Fordham? And what are some of the takeaways that you've had from events like these over the years?
Well, the great value is getting the benefit of different perspectives. So, in the great slogan of the Fordham Conference, copyright Hugh Hanson, brackets not, learn, debate, have fun. That's what it's all about, and that is what I have done. Whenever I've been to Fordham, I have learnt, I've participated in debate, and I've had fun. And as I say, it's being exposed to different perspectives. And it comes back to what we were talking about earlier about judges not being isolated but being engaged. And the great value of Fordham and indeed other fora is to learn from judges from other jurisdictions, from lawyers, from academics, and from policymakers. And it's been very educational.
Thank you. So last question, and looking ahead, what do you hope will define your legacy within the legal community? And what message would you leave with the next generation of lawyers and judges? And I put a quick caveat that no in any way suggesting that retirement is on the cards, because my very first interview when I was a wide-eyed law student in that very building that you are sitting in right now was with Lord Phillips of Wolf Matrevis. And when I asked him about his legacy, he was a little bit offended because I think he still saw himself as having many years ahead. So that's the caveat. And please take the question as you would like.
Well, I think the question of legacy is a difficult one because it's really for others to judge, not for me. It's for others to say what contribution that I have made and what value, if any, it has. Uh, I am still in the position of being, as you rightly acknowledge, a working judge in full-time employment. Doing my best to decide each case as best I can as and when it comes. And it's worth making the point, which we rather glossed over earlier, or certainly I've glossed over, which is I don't just do IP cases, as you know. Being in the Court of Appeal, I'm required to deal with other sorts of cases. I mean, that was true when I was in the High Court, but now I'm in the Court of Appeal, I have to deal with an even wider range. So my caseload now includes any legal subject bar crime. The only thing I do not do is criminal cases, but anything else I can be doing, be it family, immigration, as well as all the things that I was doing before, tax and insolvency, and so on. So the remit is incredibly broad, which brings its own challenges and rewards, as well as the core intellectual property work, which is obviously my own specialism and what I'm principally here to do, but far from exclusively. So inevitably, being an intellectual property specialist, such legacy as I may have is bound to lie in that field. I hope that I have already made a contribution in the other fields where I've been judging, such as those that I've just mentioned, but it's likely to be in the area of intellectual property. And I think it's probably fair to say that you can see my imprint more clearly in some fields than in others. And that's just a function of the cases that have happened to come my way. I mean, as a judge, you don't select your cases, the cases select you. Going back to when I was in the High Court, an obvious example was the development of web blocking injunctions, which was just something that happened to come my way. I had no idea that that was what I was going to be doing, but that turned out to be something that I was called upon to do, and that was very interesting. And it seems to have been quite influential. And not only in terms of that specific area, but in terms actually, as it turned out, of the development of our domestic jurisprudence on injunctions more generally. So one can see effects like that, how long those effects will last and whether they will prove to be of wider consequence, who knows? In the Court of Appeal, I've had other things to deal with, like standard essential patents, and you can see some effects there. As it happens, I've had quite a lot of cases on trademarks, and you can see that in the sense that I now realize that quite a lot of the leading cases in the field are ones that I've been involved in. But what effect that has had is much harder to say. As I said at the beginning, I think it's for others to judge.
Thank you. Thank you for joining us. And I would say long may the influence of Lord Justice Arnold endure.